subsection A2, but in the caption it was listed as subsection A3. We've proceeded under A2, and I believe the intent of the parties, of the state, was to proceed as though it was A2. Is that correct?
It is, Your Honor. Thank you.
All right. And so I'm inclined, just so there's no confusion, to direct the clerk to amend the cover page of the indictment to reflect that count 3 is related to that statute with subsection A2. To correct that, and I don't believe there's an objection to that. Is that right, Mr. Disford?
No, Judge.
Thank you. All right. And then the other issue that we have to address before we get to sentencing is a legal question as to whether the aggravators that the state have alleged may actually be essential elements of the crime and therefore not available to aggravate the sentence as to one or both of the counts that are prison terms today. So I think we were going to have a bit of argument on that. Mr. Bradow?
Yes, Judge. Thank you for the court allowing some argument on this issue before ruling. The aggravators were one of the questions that were always at issue in this case. And so in light of the court's conversation with counsel back in chambers, and for the purposes of the record, I will remind the court that the state has alleged aggravators under 13-701D1 and 13-701D2. D1 is threatened infliction of serious physical injury or death for the purposes of this case. And D2 is use or threatened use of a deadly weapon or dangerous instrument during the commission of a crime, and in this case, a crime involving terrorism. It's never really been a question that at least one of those was going to be considered by the court as an essential element of the conspiracy to commit terrorism count, because that charge requires that the defendant conspire to commit an act of terrorism. Terrorism is defined in 13-2301, I think it's 12, as any felony including any completed or preparatory offense that involves the use of a deadly weapon or a weapon of mass destruction, or the intentional or knowing infliction of serious physical injury with the intent to either influence some policy, and there are some other subsections. But for the purposes of this argument, the state would request that the court determine that either one of those two aggravating factors applies to its relevant portion of the terrorism definition statute. In other words, had this case proceeded to trial, this would have been an alternative situation. Either the defendant used a weapon or inflicted or threatened to inflict serious physical injury. Those comport with the two aggravating factors that we've alleged. One of them is going to be subsumed in as an essential element. The other one, under that particular subsection that would be elected for the purposes of today's sentencing, would not be. In other words, it's not necessary that the defendant threatened infliction of serious physical injury or death if the factual basis involves the use of the weapon, for example. So that could be used as an aggravator under the circumstances of the particular factual scenario going forward. That option is available to the court today. The court can say, we have evidence of two aggravating factors. One of them is an essential element of the conspiracy to commit terrorism charge. Can't be used as an aggravator, but the other one is available. And the state argues that given the or clause in the terrorism definition and the two different specific aggravating factors in 701, that the court can find that only one of them is an essential element, and therefore the other one would be available as an aggravating factor. For us to argue the upper end of the defendant's range should we elect to do that at the end of the sentencing. Lastly, Judge, I think on count 3, regardless of which way the court finds us to count 2's sentencing structure, there is an aggravating factor available to the court for us to argue on count 3, and that is the 701D1 aggravator to be used to aggravate the charge, to aggravate the sentence in count 3 and push the defendant towards the upper end of that range on that count alone. since they're consecutive sentences, that could potentially have an impact on the defendant's total sentence. So that's the state's argument with respect to the aggravators. We would request that the court make that determination today so that we can proceed. And if the court does, we will be presenting some information to the court on that issue.
Thank you. Mr. Champagne, Mr. Dixon?
Your Honor, I would give the court a few different options here. One, we clearly believe that these are both subsumed underneath the elements of the offense. As the court's read through the statute, serious physical injury and the use of a deadly weapon are inherently part of this offense. That's what creates the offense of terrorism, essentially, versus just general disruption of a public utility. Further, the definition of a deadly weapon also subsumes the notion of serious physical injury, as a deadly weapon is that which can be readily capable of causing serious physical injury. So I think we have another issue of that aspect of the definition, subsuming the serious physical injury part of the aggravator. Then, even if the court were to find for some reason that these aggravators were legally, just as a matter of first impression, legally acceptable, I think there's a strong factual argument that by alleging just threatened use of serious physical injury or the weapon, they're not alleging any conduct that goes above and beyond the elements of the offense that you'd already be convicting Mr. Khan of. And so, regardless of the legal argument, there's just a factual argument that there's no additional aggravation of fact here that the state can present that would justify that. And I would point the court, there's State Use versus Bonfiglio, which is the appellate decision, and then the follow-up that discussed some of these issues about when an element and an aggravator overlap, not going beyond the facts of a case, that you can't use it as an aggravator. So I'd ask the court to find on both of those grounds.
Thank you. Mr. Gatto, anything else?
Briefly on that last point, Judge, it's a conspiracy. The charge that we're talking about is the conspiracy charge. And so, of course, we're going to have the threatened use and the threatened use. That's the nature of the conspiracy and not the completed offense. So I don't think that argument carries a lot of water at this point in time. I would just re-urge the court on my original argument.
All right, thank you. As to count 3, the court does agree with the state that the aggravator in section 701D1 is available. As to count 2, those aggravators are both elements of the crime, and I understand the state's argument that we only need one or the other for the crime as the statute is written, and therefore, in theory, the court could potentially use the other as an aggravator. I think here, the facts of this case involve both. This was all done together. There was the threatened use of a deadly weapon, which does include the serious physical injury that can come from having a deadly weapon. We also have the threatened infliction of injury. So the court doesn't find that for count 2 that those aggravators are really available. They do appear to be essential elements of the crime. So if that informs the state then as to how you wish to proceed, do you still wish to present some evidence on the aggravator as to count 3?
Well, I mean, yes, Judge. If the court, given that ruling, needs to hear evidence, sworn testimony, we're prepared to provide some to the court. If the court is willing to find an aggravator based on legal and factual argument made by counsel, then we're willing to do that as well.
I believe that I can do it based on legal and factual argument, and I'm happy to do so. If you would prefer a more thorough record for any reason, I'm happy to take testimony. But
well, given the court's ruling and given the status of the legal argument, we're prepared just to proceed on argument at this point in time. We do wish to have the agent who investigated this matter speak to the court as part of his presentation, and he may discuss some of those issues as part of his comments.
Sure.
But otherwise, we're prepared to proceed with argument.
Very good. Any other issues we need to address before we move to sentencing?
No, Judge.
And the defense is ready to move forward as well?
Yes, sir.
All right, thank you. Before we begin the presentation, let me ask the defendant, sir, can you tell me your legal name for our record?
Mahin Khan.
And sir, what is your date of birth?
6/18/98.
Thank you, sir. The court notes that the defendant entered into a plea agreement on October 7th, 2016, which the court accepted at the time of the change of plea. Based upon the guilty plea, it is the judgment of the court that the defendant is guilty of count 1, terrorism, a Class 2 felony committed on or between April 1st, 2015 and July 1st, 2016. The offense is non-dangerous and non-repetitive. It is the further judgment of the court that the defendant is guilty of count 2, conspiracy to commit terrorism, a Class 2 felony, committed on or between April 1, 2015 and July 1, 2016. That offense is also non-dangerous and non-repetitive. It is the further judgment of the court that the defendant is guilty of count 3, conspiracy to commit misconduct involving weapons, a Class 4 felony committed on or between April 1, 2015 and July 1, 2016. That offense is non-dangerous and non-repetitive. In preparing for today's sentencing hearing, I have read and considered the pre-sentence report written by the Adult Probation Department and its recommendation. I've also, of course, reviewed the plea agreement and the stipulations of the parties in that plea agreement. I've considered the information from the settlement conference that was conducted between myself and the parties, which led to this particular plea agreement. I've also considered the state's written sentencing recommendation that was filed by the Attorney General's office and the defendant's notice of filing correspondence. There were a number of letters, and in many cases I would read off the names of all of the letters, but today I will simply indicate that all of the letters that were attached to that notice have been read by the court and considered. With that, let me ask the state if they would like to be heard or make any presentation to the court regarding sentence this morning.
Judge, I know that Agent Trevich would like to make a statement to the court, and I would like to make an argument to the court, but I would prefer that my argument be held until after the mitigation is presented by the defense, if the court please, so that I'm able to address any issues that come up at that point in time without interrupting anyone. So if Agent Trevich can speak now, we would be happy for that to occur.
All right, we will at this point hear from the state speaker, and then also we will hear from the defense speakers, and then both sides can present their sentencing arguments. Back to you.
Good afternoon. Good morning, Your Honor. Thank you for allowing me to speak. Out of respect for the family and the many friends that I'm sure will also like to speak on the defense side, I'll keep my comments very brief. My name is Benjamin T. Trentledge. I'm a special agent with the Federal Bureau of Investigation. I've been so employed for approximately 6 years. During that time, I've worked counterterrorism investigations and have been based in Tucson, Arizona. I first met Mr. Khan approximately 3 years ago in November of 2013. At that time, he had sent out a series of email messages expressing an interest in extremist activity conducting terrorist attacks. We immediately received reports of these emails and became involved with the family. At the outset of the investigation, we attempted to take a different track than the FBI would routinely take. In standard procedure, an FBI investigation is not disclosed to the person under investigation. When we have contact with a person like Mr. Khan, it's very rare that they are informed immediately that their conduct has been found to be illegal and that we would like them to change their ways, essentially, and purport themselves in a better manner. But that was the rare, extremely rare, second chance that Mr. Khan received at that time. We coordinated directly with himself and his family to attempt to find a mental health or behavioral health solution to the problem that presented itself in Mr. Khan's behavior. And unfortunately, despite the best efforts of the FBI, of Mr. Khan's family members, and of all the various behavioral health and mental health professionals who were involved throughout the years, Mr. Khan continued to revert to this interest in extremism and violence. Had he chosen to take advantage of the golden opportunity that was presented to him, we likely wouldn't be here today. He would likely have graduated high school by now and would be preparing to go to advanced school or enter the workforce as a productive member of society. It saddens me, given the efforts and the unprecedented level of cooperation that we experienced between the family and the mental health professionals that we've come to this point. But at the end of the day, the FBI has a duty to protect the public, to protect the community from the types of violence, from the extremist acts that Mr. Khan continued to revert to planning and attempting to carry out. Thus, I would request that the court consider a significant sentence today, and followed by a lifetime of monitoring. Thank you.
Thank you very much, Mr. Trowbridge.
And other than argument by counsel, Judge, we have no one else to speak today.
Thank you, Mr. Gatto. Does the defense wish to have any speakers?
We do.
All right.
First up would be his father, Atif Khan.
All right. Thank you.
Good morning.
Good morning.
My name is Atif Khan, and I am Mahin's father. And I will, Your Honor, like you to know that since Mahin has been imprisoned, he has shown significant signs of remorse for his actions. He understands now that his words can have serious consequences. I request you to please take into consideration when sentencing Mahin today that this is his first time in trouble with the law, and he was a minor when everything occurred. He lacks the mental capacity of an adult or the maturity, and in today's world where social media and video games are so influential, he was not able to understand that his words would land him into the situation he is currently facing. He has always struggled to adapt, and he has been in several different schools. I request you to please place him in protective custody, as he has already been attacked once, and that is for a fact, and his life is in danger. Mahin is loving, kind, and respectful, and at weekends he will look forward to spend time with me. We would go out hiking, bowling, to the movies, and eat together. We had spent many great times together, and I miss him so much that my words can hardly express it. Mahin has great family and community support, and you can see that for yourself. And we will try our best to ensure that he can reintegrate into society as a useful member once he is released. For that reason, if you can please consider placing him in Pima County, because that will be easier for us to maintain a close contact, relationship, and bond with him over the years. So that will facilitate his reintegration into the society. I hope, sir, that you are able to see that in reality he is a lost and confused child who needs help. Thank you, Your Honor.
Thank you.
Next up would be his sister, Sohar Khan.
Good morning, ma'am.
Good morning, Your Honor. I stand here before you today, trying to maintain my composure as best that I can. What you don't see What you don't see is how much I miss my brother and how every day I put on an artificial smile and go about my day just so my parents can have some sense of normalcy in their life. It is so painful to go about everyday life knowing that your brother is suffering behind bars and it remains a mystery as to when he will see daylight again. As a mother, I feel so helpless when my daughter begs to go play with her uncle and looks at me with tears in her eyes when I explain to her that this is no longer a possibility. I think it is imperative that everyone in this room knows that Mahin is not at all the person that these charges have painted him out to be. Mahin is the sweetest uncle, and his love for his niece and nephew have always warmed my heart. Standing here today feels so surreal. I still do not understand and struggle to comprehend how things have escalated to this point. What I do know is that I see the remorse in my brother's eyes. I hear it in his voice every time we have a video chat. I can see it in his eyes today. I know that he yearns to play with his nephew and just hold him one last time. I know that he had no idea the severity of the consequences that his words would carry. I know that he regrets his words. Studies have proven that the rational part of a teenager's brain does not fully develop till a person is 25 years old. Mahin was just 17 when he made the comments that he made. 17 years old. That would mean that he was legally still a minor who was still very much traumatized by the death of his brother. I fully believe that he never intended to, nor is he even capable of harming anybody. The Mahin I know does not have an evil bone in his body. What he does have, Your Honor, is a family who loves him immensely and misses him. He has a tremendous amount of family and community support, and I look forward to the day that he can get out and close this chapter, because that's all this truly is, a chapter in Mahin's life. This in no way, shape, or form defines him. I ask that you please consider placing him in protective custody, because I know every day his life is at risk if he were to be placed amongst the general population. I further request of you to please place him somewhere where he can obtain counseling and psychotherapy, and if at all possible, in Pima County, so my children are able to maintain a relationship with their uncle who they love dearly. Lastly, I am begging you to give Mahin the minimum amount of time that this plea bargain will allow you to, and please keep in mind that your decision today has an incredible impact on my entire family, including my children. This concludes what I need to say, and I thank you sincerely for your time.
Thank you, ma'am.
Next would be Auguste Alcara.
Good morning, sir.
Good morning.
Can you begin by spelling your name for my staff, please?
I have a severe hearing problem. Are you asking for my name?
Yeah, I'm asking you to please spell your name for my staff.
Auguste, and the last name is Elkareh.
Thank you, Mr. Alcaria.
I would like to preface my statement by saying that I'm not a Muslim and I'm not from Pakistan. I was a professor of electrical engineering for over 2 decades, and about 3 years ago I was asked to tutor Mahin. It didn't take long before I realized that he has no mental capability of understanding mathematics or science. I advised his mother to send him to a vocational school. In my opinion, jailing Mahin would not serve any purpose. I think it's better to send him to a vocational school or a rehabilitation school under close supervision, where he has no access to the internet or phone, and where he can be indoctrinated that what he has been doing or intending to do was very evil. So I beg the court to consider the possibility of sending him to a rehabilitation center where I think society would be better served. Thank you.
Thank you, sir.
I apologize. The next one would be Rizwan Safdar.
Good morning, sir.
Good morning, Your Honor.
I'm gonna
Ladies,
ask you also to spell your
Sure.
name.
Izwan, and my last name is S-A-F, F like Frank, D. David A.R.
Thank you, Mr. Safdar.
Thank you, sir. Your Honor, ladies and gentlemen, good morning. My name is Rizwan Safdar. I'm a board-certified gastroenterologist working in Tucson, and I have known Mahin Khan for the last 15 years. I have children who grew up with Mahin Khan. His family and our family are very good friends. Whenever we go to San Diego or to White Mountains for vacationing or camping, he's always with us. I've never ever found him to be dangerous to any of my children or the people nearby. We have a dog, it's a German Shepherd, and Mahin loves that dog. He would hug the dog, he would be so kind to my children and to his friends. However, there is a serious problem, and the problem is mental development. In our society, we try to fit one size for all. In schools, in universities, everywhere. It doesn't work. There are some children who are not born with the same IQ and mental capability like others. Some excel, some don't. And some who have cognitive problems, they are the worst ones because they are socially and psychologically inept to the society and cannot deal with their peers. And that's exactly what happened with Mahin. He was suffering with social isolation. My kids would not work with him or would not go out with him because what he says he doesn't understand. They have consequences. That these words do carry weight on other people's emotions and they have results that come afterwards. And unfortunately, because of this, we are in this tragedy where the family is missing the child, where Mahin himself would feel terrible about all this, but nothing can be done about it because whatever he said is a fact. So what I request the court to please strongly consider a rehabilitation. In my opinion, being a physician and being caring of people, our goal is not just to punish people, it's to rehabilitate them. Why see smokers who smoke all the time with lung cancer? We still treat them. We still tell them stop smoking, or alcoholics who drink alcohol and they have a burnout pancreas. We still ask them, please stop drinking alcohol. We try to rehabilitate people. So the goal is to how to get him better and rehabilitate back in the society. And I beg the court and your highness to please consider this as really a matter of psychological and cognitive dysfunction that resulted in this nightmare. Thank you very much for giving me the opportunity to speak. Thank you, sir.
Good morning, Your Honor, ladies and gentlemen. I'll spell my name. I-R-F-A-N, last name is Sheikh, S-H-E-I-K-H.
Thank you, Mr. Sheikh.
I've been in USA since 1987. I've been working with high school kids since 1989. I have worked with several hundred kids. I came to know Mahin about 5 years ago. 3 years ago, I tutored him twice a week for 3 months, and I did realize that there is some problem. However, and I'll make it very simple and short, last year we planned a trip to Casa Maria, which is a soup kitchen service in Tucson. During our Ramadan month, when we were fasting without food and drink, we spent half a day there preparing food for 300 to 400 people. He was with me. At the end, I asked him, how did he feel? He said, it was great to work with my brothers and sisters. And if you plan this again, please let me know. So, Your Honor, I'm going to say, this is not the person who is filled with hate for others. And I do wish we can find some treatment for this young man and save him. That's all I would like to say. Thank you.
Thank you.
Bismarck.
Good morning, ma'am.
Good morning. My name is Bisma Khan. That's Bismakhan,
Thank you, Ms. Khan.
and I am Mahin's cousin. I have known Mahin since he was born. I adore him as if he is my own brother, and I struggle to remember a time in my life that he wasn't there, or even a single time I saw him being anything but the lovable Mahin I know him to be. He would often get annoyed because I would know every thought in his head, or how he would react to any given situation. I spent many days with Mahin, as a sister, as a friend, and as a confidant when he went through his toughest times. I've always treated him differently than I would any other person, because I knew that he was sensitive, naive, and gullible, but beyond all kind and caring. At this point, I can only ask that you hear what we have to say, and please take into consideration every statement you hear. Mahin has been hurt. He has expressed regret for his actions. He knows that the mistake that he made was wrong, and he can barely go a day without talking to someone in our family. And this has all taken a huge emotional toll on him and everyone that cares about him. He has an enormous family and community of friends, more than those that are here today, who adore him and know that he can do no harm. And I hope that you are able to see that. Thank you.
Thank you, Ms. Khan.
Ms. Mahin Khan?
My name is Usman Khan, Usman, and I'm Mahin's cousin. Growing up in a joint family, I got to know Mahin as a brother. From the day he was born, he was a loving and caring individual. His love isn't shown from his deeds, it's shown from his love for his family, friends, and strangers who he accepts in his life with open arms. I remember all the fun times we had together, from taking late night trips to get ice cream, any place that was open, to taking a run across the street, see who can run the fastest. It's the little things that really got to him and he loved. His innocence is shown by his accepting nature and allowing those he doesn't know into his life and giving him all the love and attention so he could have that best friend. I remember every time he would find out I was coming to visit Arizona, he would get very excited and make excessive amount of plans so we can spend as much time together as possible. When the time came for me to go back home, he would immediately ask me, when are you coming back? Mahin made a mistake when he was a teenager, which in turn has brought us to where we are now, Your Honor. I ask you to please take into consideration for all the love and support from his family and friends and everyone else. Thank you.
Thank you.
Mariam, here.
Good morning.
Good morning, Your Honor. Good morning, everyone. My name is Maryam Mir, M-A-R-Y-A-M. Last name is Mir, M-I-R. Thank you for giving me the opportunity to speak today. As family friends of a Khan family, I would like to ask for leniency for Mahin Khan because of the following. Mahin Khan has grown up with mental health issues as well as with autism. He has gone through a detailed inpatient psychiatric evaluation under the supervision of federal authorities for the past 3 years. According to mental health professionals, his mental age is less than 13 years old. Because of his mental health challenges, I ask the court to consider his sentencing to be held in a secure and safe environment, such as in a state-approved mental health facility, and hopes he will receive proper treatment to meet his special mental health needs. If this is possible in Pima County, that would be even better for the family and friends. Thank you for considering my request. We hope that Mahin Khan will improve through treatment for his own self, for his family, and for his community at large.
Thank you, Ms. Lee.
Thank you.
His mother, Shazia Khan.
Good morning.
Good morning. My name is Shazia Khan, and I'm Mahin Khan's mother. I want you to know how much I have been suffering since the day Mahin was taken from me. He's the only son I have. and my whole life is all about Mahin. Mahin and I would spend every day together. At the night time, he's 18, but he always tell me that, "Tuck me, Mom." I didn't hug him past 4 months. He hugged me every time, like millions of times. He walked with me every day. He would always sure I walked. He hold my hand whenever we would go walking. Mahin loved his niece and nephews more than anything in the world. He spent a lot of time just playing with them in the summer. They swim all together. Mahin is always helpful around the house and help me clean all the time. Mahin, he is a mind of child, and I'm begging you to please think about it when you sentence him today. Mahin is not an adult. He's a kid who is lost and confused. He did not understand the troubles his words could get him into. I want you to know that when you're sentencing Mahin today, you're sentencing me also, because my life is nothing without him. Please take mercy. It's your hand now. Everything.
Thank you, Ms. Khan.
And finally, Judge, Reed's fired.
Good morning, Your Honor. My name is Reed Spire.
Can you spell your name for us?
R-E-E-D-S-P-I-R-E.
Thank you, Mr. Spire.
My name is Reed and I am Mahin's brother-in-law. I want you to know the impact that this had on my family. I watched my wife cry herself to bed at night because she misses her brother so much. Watching my family suffer this way has been unbearable, and I find myself wishing there was something I could do to take away their pain. I have some of the greatest memories with Mahin because Mahin is truly like a child, and nothing made him happier than when we would take him out for hot dogs and soda after a good workout. I really enjoyed and learned from Mahin because he taught me to appreciate the simple things in life and not to get so caught up in all of the details and seriousness of my own adult life. When Mahin was arrested, I lost more than just my brother-in-law. I lost a friend, and over the years, Mahin had become a little brother that I wish I always had. And now I just miss him so much, and there isn't a day that goes by where he doesn't cross my mind. My daughter asks for her uncle every day, and she knows her uncle isn't around, but just doesn't quite understand why. And my 10-month-old son, one day I would like him to know his uncle. Mahin loves his niece and nephew, and I can only imagine how difficult it is for him to be away from him. My family is incomplete without Mahin, and I'm asking consideration in sentencing Mahin today. Thank you for your time.
Thank you, Judge. That's all speakers we have.
Thank you. Get out. Would you like to be heard at this time regarding the sentence?
I would, Your Honor. The state will be asking that the court impose the maximum sentence that you can under the law, as the court has made its rulings today for the following reasons. I want to talk a little bit about some of the mitigation that the court has heard in the last half hour or so, because I think the court's required to consider it. And I think that from the state's perspective, it should not be given the amount of weight where the court has discretion, that you otherwise might consider. The defendant's age is the only real mitigating factor that I can see in the circumstance here, Judge, and it can be outweighed by his conduct in this case and by the nature and circumstances of his crimes. While he was a minor during the commission of the conspiracies in this case and the completed act of terrorism that he did in this case, that alone is not enough to either justify his conduct or excuse it in any way. He knew exactly what he was doing the entire time he was engaged in this conspiracy involving communicating with an undercover agent about making bombs, figuring out places to detonate bombs, discussions about the numbers of people that he wanted to kill and the numbers of people that he wanted to see die, expressions of interest and approval of large-scale terror attacks that occurred around the world during the time period of his communication with this person. All that is detailed in his interview with the FBI agents in this case. For the first 86 pages of a double-spaced transcripted interview, he lies to them over and over and over again. I'm not interested in that. I'm not a terrorist. I'm not a jihadist. And only when they tell him that they know everything that he's been doing does he finally come around and say, I'm an ISIS supporter. I'm a jihadist. I want to blow people up. And at the end of the interview, he tells them he wishes, when he learns that there's a search warrant going on at his home, he wishes he had set up a pressure cooker bomb to blow them up as well. Those are the two sides of this defendant that the family and friends that have spoken to the court today can't see and didn't see. They didn't see the side that he didn't want them to see. The court can consider and listen to the people that know and love the defendant and understand that they were present in his life all along. They were present during the time that he was engaging in this conspiracy. They were present to try to intervene with him throughout the course of this set of crimes. One can feel badly for all of them and understand what they might be going through, now knowing what he was doing under their noses and behind their backs, without feeling a need to release him into their care a minute sooner than the court's required to. They're simply not equipped to deal with him. He is a person who wants to hurt other people. And he expressed that a number of times in the course of his conspiracy in this case and in his interview with the FBI. I think Agent Trentledge's comments to the court were particularly instructive. He talked about the efforts that the FBI went to deal with the defendant. I think from the comments that he made, it's clear that he didn't want to be standing here in front of Your Honor sentencing the defendant to prison on these charges. They wanted this to be resolved in some other way. Wanted the defendant to be a productive member of our society. Unfortunately, if he's ever able to do that, it's not going to be for a long, long time. I want to address some of the comments that were made about words, Judge, and I just want the record to be very, very clear. We're not prosecuting words here, just words. I think the court understands that, but everyone needs to understand that a conspiracy was committed here, and acts were committed. Plans were exchanged to build bombs. Instructions were given on how to do that. This is not just someone sharing words and talking about political philosophy. This was a conspiracy to commit crimes against people whose lives would be irrevocably changed at a simple visit to the MVD if this plan had come through. The FBI's efforts just couldn't go on forever. Eventually something had to be done. And yes, it did happen when he turned 18, because at that point, a lot of the family structure and a lot of the family control that otherwise might be available to the FBI to lean on would be gone. So that's why we're here now. Just to make that issue clear. I think all the factors that a court normally considers in sentencing a defendant can be accomplished by a maximum prison term under the options available to the court. While I understand the need for rehabilitation for a younger defendant, I think that The Attorney General's office understands that need, which is why this plea agreement was made available to the defendant in the first place, in part and in measure. There has to be a consequence, price to be paid first, a punishment. And that's what we're asking the court to impose in the form of a sanction of a lengthy prison sentence. There's also the goals of societal safety and just removing the defendant from society for a period of time so that people can feel safe, that he's locked up for a while. And the long-term goal of rehabilitation can be accomplished once the defendant is released. It's our hope that the court is intending to impose a period of lifetime probation on the terrorism charge count 1 when the court imposes the sentence. The court is well aware that defendants can earn their way off of lifetime probation if they successfully complete terms and conditions, if they're doing well. Those things are available to the defendant down the road. Initially, however, this case has to require a lifetime probation term at the end. As an initial matter, the defendant needs to be supervised in the community with the expectation that he will be, on his part, for the rest of his life, unless he does well. The people in this state deserve to feel safe. The defendant poses a danger to the community right now. The only viable option is to remove him from the community for a period of time and supervise him for the rest of his life until he can demonstrate otherwise. So what's the appropriate punishment for a conspiracy, Judge? Well, that depends on the nature and the facts of the conspiracy. In this case, this defendant wanted to create major havoc. He wanted to create major destruction and loss of life. That was his primary goal. The FBI was onto him, and they knew, so it didn't happen. But if it had, hundreds of lives, families, would be affected. Well, we want to take into consideration the defendant's mitigation, and I know that the court and the responsible prosecutors consider those things, as we did. At some point, that mitigation has to be outweighed by the aggravation and just the nature of the case, Judge. In this particular case, the court should send a stern and unmistakable message to the defendant. This is not going to be tolerated, and he's going to end up in prison again if, once his term here is done, he starts again. And the only way to do that is to send a maximum sentence. You may hear some comments about how prison is a hard environment. It's only going to make him worse. It'll only harden him against the American government, our way of life, his core hatreds, institutionalizing him, all of those things. I respond to that's an illusory concern. Every defendant who goes to prison in the criminal justice system is faced with a choice. You go in, and you can either come out better, or you can come out worse. If he comes out worse, it's on him and him alone. And he'll be faced with lifetime probation and a lot of responsibility when he comes out. He's got a choice. If he's been rehabilitated in jail, if he's done well, and if what his family is saying is right and true, then he will not have any trouble with his prison sentence as well. But if not, and he's the same jihadist that he was the day he was arrested by Agent Trentledge, then that will also play out in the long term of his prison sentence, and it's an additional reason to consider a maximum term. Judge, this plea agreement represents a compromise, and it's a prison range that the state was comfortable with at the time that we entered the plea agreement. It takes into consideration the defendant's mitigating circumstances such as they are, and also allows the court to impose a lengthy term of prison and a lifetime probation tail. It is the state's request that the court do that and sentence the defendant to 8 3/4 years. I think you can easily get to the super aggravated term on count 3. And lifetime supervised probation with the terms and conditions that are laid out in the plea agreement. That's my answer. Thank you.
Thank you. Mr. Schaefer?
Yes, Your Honor, I was going to begin. I want to discuss some of the legal issues with the sentence. I know the court, having ruled on the aggravators and having seen that these aggravators were alleged right before sentencing, and come to the conclusion that we weren't able to litigate these before the plea agreement took place. Now hearing that Mr. Gatto has asked a request for an aggravator on the conspiracy to possess a deadly weapon charge, you look through this and you see that at trial likely the state would have been able to prove essentially that a Class 2 felony was committed and that there was no aggravator therefore capping at 5 years the sentence and allowing lifetime probation. And then on the conspiracy charge, to be in that same boat, to be capping on a Class 2 felony at 5 years and having no opportunity for lifetime probation. And then on the conspiracy to possess a deadly weapon charge, misconduct, again, having a range of probation up to 3.75. Now, the harm to Mr. Khan would come if the court, based on the facts of the case, desired to stack those in any way. And I would point out that the plea agreement that Mr. Khan's taking stacks those charges automatically. He's going to be going to prison on one, prison on another, and then he's going to be coming out on probation. So each one of those charges is consecutive to the other. Now, looking at the actual facts that were charged by the state, the comments from Mr. Khan about a conspiracy to attack the DMV occur on the evening of June 6th into the day of June 7th. It's a very strong argument that after trial, those events would have essentially become a single act. His statements come through email and come through text, and they're with the undercover agent. And those exact statements, and I think it's important to focus on the facts here, is that he's stating to the undercover agent not that there's an imminent threat, but that he assures him that patience is key. He says, wrong timing is the worst thing that can happen. He says, I have new targets for you, so targets that have not been mentioned before in his months of essentially fabricating the San Bernardino, or I think it was the San Jose FBI office, the San Francisco FBI office, just the mall, the JCC Peter Pepper Pizza, essentially just listing out targets every single time this undercover agent goes, well, tell me something else, tell me something else. And on this June 6th date, or this June 7th date, that's when you're first hearing about this DMV, which is ultimately the charged act, because it's actually a state building and public service. And that continues there. So I think when looking at this case, not only are there no aggravators, but there's a very weak argument for even stacking the discussion, the agreement, the conspiracy charge, and the terrorism charge at all. Now, in terms of the conspiracy to possess a deadly weapon, it appears what the state's discussing there is a hand grenade, and a discussion that occurred about a hand grenade, and they say, and the directions that were sent. It's important to note there, one, the directions are freely available on the internet. You or I could look at them in a moment. Many teenage boys do look at things like that. It's sent in an email to an undercover agent. And in the discussion that occurred in the text there, and again, I think the actual phrasing is very, very important. Mr. Khan is saying, I don't want to get blown up. You make it, you make it. I don't want to get hurt. And so, again, you have statements that are bad, statements that will show an agreement. But the quality of that conspiracy is not like we've seen a conspiracy to commit murder where an individual is going, I'm going to kill so-and-so on a certain day. Like, I want you to hire you to do that. Instead, what you see is a child who's talking to an undercover agent who's progressively encouraging them, give me a target, and he continues to give him this, that, and the other thing. Who's progressively encouraging him, will you meet with me? Mr. Khan's going, yes, I'll meet with you in 2 days, and never meets with him. And on the actual date of the conduct charge, it's June 6th to June 7th, you're seeing essentially the weakest limiting of some sort of conspiracy here. I mean, you're seeing an agreement to bomb a DMV. I think the state has acknowledged before, and they have to acknowledge from the facts, there are multiple DMV locations in Mesa. They don't have an address or any information. The undercover agent asks, are there photographs of this DMV? Again, Mr. Khan says, no, I don't have pictures. Just look it up on Google. The extent to which there's a harm here or a harm that should be stacked is very minimal. And I would point out that obviously the mention of the Islamic State is driving a lot of this prosecution because there is a substantial amount of prosecutorial discretion in Arizona on charges like this. I myself have represented individuals who are charged with the Class 4 terrorism statute where they actually provoke an emergency response, where they call up essentially Sheriff Joe's office, say, I will bomb you on a specific date and time. And those individuals are charged with a Class 4 felony. I personally, in these courts, have pled individuals to Class 6 open felonies when they had prior felonies for engaging in activities like that, adults. So I would like to sum up by addressing the actual aggravator then for the conspiracy for a deadly weapon. Not only do I not believe that these charges should be stacked, but the use of the deadly weapon aggravator on this count 3, the actual charge that the state's discussing, this A2 subdivision, is carrying a deadly weapon if you're under 21. And as I argued before, even if the court's willing to take that legally, factually, the discussion about a pipe bomb is not any different than the actual conduct that they are charging. They're charging that a weapon, that there was a conspiracy and agreement to get a weapon that was going to cause, be readily capable of causing serious physical injury. And then they're alleging that as the aggravator, and then asking the court not only to find that aggravator, but then also to add a catch-all aggravator on top of that. I believe under these facts, there should be no aggravator whatsoever on count 3, and that once the enumerated aggravators are removed, the court cannot use a catch-all aggravator at all. That's forbidden under state legally at all. The sole use of a catch-all is not permitted when no other aggravators are found that are enumerated. And finally, in terms of this discussion about whether mere words are crimes or not, I would like to point out, one of the reasons that I personally went to law school was taking civics classes, where Justice Brandeis very famously told us, if there be a time to expose through discussion the falsehood and fallacies, and to avert the evil by the processes of education, the remedy to be applied is more speech and not enforced silence. And throughout this prosecution, from the use of 3961D to preventatively detain Mr. Khan, and through the charging at such a high level on a charge that arguably could lead to life imprisonment based on the state's allegation of aggravators, you've seen the state aggressively using the law to enforce silence. Now, I agree with Agent Trentledge that in the 68% or 60% essentially of these informant cases where the FBI has encouraged the individual to engage in some sort of conduct, that it's very unusual for them to contact the individual at any point and to engage in discussions with them. But I would point the court that the United States is not the only country in the world that is dealing with terrorism. And other countries, such as Denmark, actually have progressive programs in place where individuals actually have flown to Syria, engaged in actually fighting with enemy combatants in Syria, and have returned to those countries, are not met with 20 years in prison, 15 years in prison under material support statutes in federal courts, as they often are in the United States. Those individuals are brought back, they're given mentors, and the state has spent a substantial amount of resources making sure they could reintegrate young men into their society without punishing them. So while I can appreciate the FBI's actions in this case, where you need for the FBI, in the global response to these sorts of acts, I do not believe that it would be considered on the most lenient side, and the court should take that into consideration. Thank you.
Thank you, Judge. Obviously, our recommendation on this case is for 7 years. It's the lowest we can get under the plea agreement. I think what Mr. Champagne is essentially arguing, as far as the stacking, any aggravation that the state proves, that should justify why the 2 counts are stacked. I keep thinking back to when we did the settlement conference and you made a statement that this is kind of an emotional charge. You hear terrorism, and all of a sudden you're filled with all this emotion, all these thoughts and feelings kind of come in. You're thinking 9/11, you're thinking the Boston bombing, you're thinking, oh my God, my family, my friends are in trouble. But in this particular case, once you start peeling back the layers and you start looking at each individual and you start talking to people, it's not the same thing. When I got the call and I went out to the jail and I met Mahin for the first time, I saw a child. I saw a goofy kid who was kind of not all there. His family has talked about his mental health issues, and I think they're right. He does have mentally ill problems. Agent Trentledge said that the FBI went out and did something that they'd never done before. They went out and said, hey, you should get this kid some psychiatric help. But that's the issue. You see the kid up on the ledge, do you continue to help him, or do you push him off? Why did you stop? Why not continue to follow up on Mahin and make sure that he's getting treatment and help? Why say that the mentally ill child that had the golden ticket and got the one chance to get out of jail free, but because he wasn't able to control his impulses, well, now he's going to prison? There are a lot of mitigating factors. Mahin is a child. He may be legally an adult, but he's still a kid, and kids make stupid decisions. He does have family support. First meeting I had with his parents, you could just see the pain in their eyes as they struggled to deal with the ramifications of what Mahin was facing, and with the struggles that they've had in trying to deal with Mahin's mental health issues. This has not been an easy road for any of them. Mahin has accepted responsibility. He took a plea. He's going to prison. This is a statute that if we were to go to trial, you could get anywhere from probation to life in prison. The ramifications were very daunting. But in that first meeting I met with Mahin, he's like, I just want a plea. Give me a plea. The first plea offer that I got, I told his parents. His parents told Mahin. Mahin said, okay, I'll take it. He didn't even know what the facts were. He didn't even know what the details were. He was ready to accept responsibility. He just wanted to get this over with. I think that also kind of shows him his immaturity a little bit. He's never been to prison before. He doesn't have any prior felony convictions. He has poor impulse control. He has mental health issues, and I think that is the driving factor behind these cases, behind this case. I spent a lot of time talking with Mahin. He understands what he did was wrong. He knows what he did was wrong. I think 7 years is a long time in prison for somebody that's never been in jail before, for somebody that's never been to prison before, for somebody that's coming out with a probation tail to help monitor him. So it's not like he's going to go in and finish his time and that's going to be it. No, they're going to continue to monitor him. And I would ask for 5 years of probation because I think that's appropriate. I don't think lifetime is appropriate. I think 5 years of probation would be sufficient. But I do think those are a number of mitigating factors as to why the court should impose 7 years. It's a difficult case. I understand that. Obviously, it's high profile. Lots of people are interested in it. Great subject, it's a flashy headline. Mahin is a child. Legally he's an adult, but he's a dumb kid. 7 years is sufficient time in prison, followed by probation time. And that would be my recommendation, Judge.
Thank you. I'm going to ask Mr. Khan to come to the podium.
And, yeah, we can come, and he will not be making any statements.
All right. Okay.
Bye.
And just to make sure the record's clear, Mr. Khan, you know you can speak to me if you wish today, but you do not wish to, is that right? Well, this is a difficult case for a lot of reasons. I'm being asked to look at the defendant as he stands before me as a young man who has poor impulse control and mental health issues. I think he's been described as a goofy kid who's not really all there. And those are things that courts look at when we decide sentences, and those are things that are mitigating factors. By the same token, however, those qualities, I think, are common in people who do actually commit very violent acts against the community, whether they be mass shootings, whether they be inspired by some form of political terrorism or whatnot. Young men in their late teens and 20s with some of those qualities, I think, are frequently the folks who are able to unfortunately carry out some of these activities. So this is a difficult case, and the court has heard what everyone has presented today. The court does find that probation is not appropriate for either count 2 or count 5. The court does consider as an aggravating circumstance, as we discussed as count 3 earlier. Oh, did I say 5? Count 2 or count 3? I apologize. The court has considered as an aggravating circumstance as to count 3 that the offense did involve the threatened infliction of serious physical injury. The court does find the defendant's age at the time of this offense to be a mitigating circumstance. The court does note that the defendant enjoys strong family and community support, and that is also a mitigating circumstance. As to count 3, the court finds that the aggravated circumstances, or the aggravated circumstance, is sufficiently substantial to warrant an aggravated sentence. For count 3 of CR 2016-005270, it is the judgment and sentence of the court that the defendant be imprisoned in the Arizona Department of Corrections for the aggravated term of 3 years, and you are given credit for 127 days of pre-sentence incarceration. As to count 2, the court finds that the presumptive sentence is an appropriate sentence. So for count 2 of CR 2016-005270, it is the judgment and sentence of the court that the defendant be imprisoned in the Arizona Department of Corrections for the presumptive term of 5 years. On that matter, you are not given credit for any pre-sentence incarceration, as I'm ordering that the sentences on count 3 and count 2 shall run consecutive to one another, bringing the total time in prison to 8 years. It is ordered waiving the community supervision requirement to allow the defendant to serve a consecutive probation term in count 1. It is further ordered directing the clerk to send to the Arizona Department of Corrections my sentencing order, copies of all pre-sentence reports, probation violation reports, medical and mental health reports prepared as to or relating to Mr. Khan. For count 1, the court finds that probation is warranted because of a need for continued monitoring upon release from prison. It is the judgment of the court that for count 1, the imposition of sentence is suspended and the defendant is placed on lifetime supervised probation. The terms of probation will begin following the prison term on counts 2 and 3 in this case. There are several terms of your probation, Mr. Khan, and all of them are important. I'm not going to read all of them to you today. We're going to give you a copy, and you need to read and carefully comply with all of those terms. I do wish to highlight a few. While you are on probation, you're not to consume or possess any alcohol. As stipulated in your plea agreement, I am imposing all of the mental health terms, the white-collar terms, and the computer usage terms, which will limit your ability to access the internet, among other things. I am requiring that you will surrender your passport to authorities. Additionally, you are not to travel outside of Maricopa and or Pima County if your probation is transferred to Pima County. You are not to have any contact with any member, affiliate, or sympathizer of any terror group listed by the United States State Department. You're not to visit websites or obtain materials advertised by such groups, and you are not to travel outside of the United States. You may not possess any weapons, explosives, weapons of mass destruction, or plans or instructions for building or making such devices. I am ordering that you're eligible to have your probation transferred to Pima County so that you may reside there, provided that the Pima County Adult Probation Department is willing to accept that responsibility. If you violate any of the terms of your probation, you can be brought back into court, and if they prove that violation, you can be sentenced to prison for count 1, and you may receive a term of up to 12 and a half years. You are advised that you need to maintain contact with the Adult Probation Department at all times. You should contact them within 24 hours of your release from prison, and you must maintain contact with them at all times. If you fail to do so, not only can they revoke your probation and send you back to prison, they can enter something called a criminal restitution order for any of the fees or fines that you owe the state. If they do that, then the amounts you owe start accruing interest. They can charge collection costs, place liens on any property you own, etc. It is ordered that you will pay a one-time probation assessment of $20, a one-time time payment fee of $20, a monthly probation fee of $65, and should you choose to have or ask that your probation be transferred to Pima County, there is a $150 inter-county transfer fee that must be paid. It is further ordered that you will pay each of those fines, surcharges, and fees beginning the first day of the 4th month following your release from prison. It is further ordered that you shall submit to DNA testing for law enforcement identification purposes as required by Arizona law. On the motion of the state, the matters that are set forth in the plea agreement for dismissal are